In Australia, nuisance and trespass are two different legal concepts that often arise in neighbourhood disputes, and understanding the distinction is essential to resolving property conflicts effectively. Nuisance refers to the interference with a person's use or enjoyment of their land, and it can either be private nuisance affecting a specific individual's enjoyment of their property, or public nuisance affecting the community or a class of people. Common examples of private nuisance include excessive noise, strong odours, smoke, or water runoff that substantially and unreasonably interferes with the owner or occupier's use of their land. To succeed in a nuisance claim, it must be shown that interference was substantial, unreasonable, and caused real harm or inconvenience. In contrast, trespass involves direct physical interference with land without permission. This can include entering another person's property without consent, placing objects on someone else's land, or even causing something to intrude, such as debris or overhanging branches in certain circumstances. Unlike nuisance, trespass does not require proof of damage. The mere unauthorized entry or interference can constitute trespass. The legal consequences for nuisance and trespass can differ. Remedies may include injunctions to stop the conduct, damages to compensate for loss, or both. In nuisance cases, courts will balance the nature of the use, the locality, and whether the interference was reasonable in all circumstances. For trespass, liability typically arises from the act of entering or interfering without consent, regardless of the reasonableness of the conduct. Because neighbour disputes can be highly fact-specific and emotionally charged, early legal advice helps clarify rights, obligations, and the most appropriate legal avenue for resolution. Contact us today for a free 30-minute consultation with one of our experienced team of litigation professionals, and let us help you protect your rights.